Good afternoon, everyone. Good afternoon, everyone. We're going to go to introductions in just a quick second, but first I just wanted to make a couple of quick announcements. I do trial work in state court and federal court, and federal court's a little more formal than state court. And frankly, I don't like it. I prefer to have, I prefer to be more informal. So I'm going to let you guys try your case like you're in state court. If this were a real courtroom, that would mean you could get up and you can walk around and you can approach the witnesses without asking. Obviously, that's not going to be going on, but you can still get up and move around if that's what you prefer to do in your case. That's completely up to you. In regard to objections, what I'm going to encourage you to do is, if you're the one making the objection, state all the grounds. If there's 2 or 3 grounds that you have, state them all at the front end, because then I'm going to go to the other side and ask them how they want to respond. And I'm going to encourage them to respond to all of the grounds that you laid out. And then once they've had an opportunity to lay out their whole record, I'll come back to you and let you wrap it up. And then I'm going to make a ruling. For the most part, there may be an exception. There may be something really unusual where we go back and forth more than once. But I'm going to try and move the trial along very quickly. You make your record. They respond. You add anything. If there's anything to add, I make my ruling and we go on. Does that make sense?
Yes,
Okay.
Your Honor.
Excellent. So
Yes, Your Honor.
Great. So why don't we have Mr. Spillner and his witness, the prosecution team, identify themselves, or the plaintiffs rather, and then we can have the defense introduce themselves after that.
Yes, Your Honor. Good morning, Your Honor. My name is Jack Spillner on behalf of the plaintiff, Mrs. Ethel Marks, who is representing the deceased, her daughter, Jessica Marks. I'm here with my second chair, Natalia Ortega.
Good morning, Your Honor. Good afternoon, Your Honor.
Good afternoon, Ms. Ortega.
She'll be timekeeping and screen sharing exhibits and demonstrative aids. I'm also here with my witness, Morgan Levin.
Good evening, Your Honor.
And that
Good
concludes the
evening.
introduction from the plaintiff, Your Honor.
Good afternoon, Mr. Levin. Thank you, Mr. Spillner. Let's see, it's Ms. Hill. Ms. Hill, would you please have the defense team introduce themselves?
Of course, Your Honor. Good afternoon, Your Honor, at least from where I'm at. My name is Charlotte Hill, and I'm joined by my second chair, Ms. Ashna Parekh.
Good afternoon, Your Honor.
Good afternoon.
She'll be off screen today, helping with any technical matters, as well as my witness, Ms. Sunny Mehta.
Good afternoon, Your Honor.
Good afternoon, Ms. Mehta.
Today, we represent the defendant in today's case, Sunny's Rooftop Bar.
Thank you very much, Ms. Atherton. Oh, pardon me. I'm sorry. I misspoke. Ms. Hill.
No worries, Your Honor.
I'm sorry. I was looking at the wrong note. So why don't we start with Mr. Spillner? Do you have any pretrial motions or anything that you want to address before we get started?
Yes, Your Honor. We invoke Rule 615 that all witnesses except the party representative, Sunny Mehta, are constructively sequestered.
Ms. Hill, you okay with that?
Yes, Your Honor. We'll be designating Sunny Mehta as our party representative today.
Motion granted.
And as stated in pretrial evidentiary ruling 11, exhibits 1, 22, and 23 are pre-admitted and their contents may be used at any time.
Okay. I assume you have no objection to that, Ms. Hill?
No objection, Your Honor.
Excellent. Okay.
And lastly, we would request that all witnesses be constructively sworn in.
Absolutely. Okay.
And
Anything
nothing
else?
further from the plaintiff.
Okay. Ms. Hill, do you have any motions or anything that you want to bring to my attention?
Just one more thing, Your Honor. Since this is our first time in Your Honor's virtual courtroom, we were wondering Your Honor's preferences when it comes to sharing demonstrative aids and exhibits, since obviously we can't be approaching witnesses.
This is your case. I want you to be comfortable and do whatever you want to do to make your case. I don't want to get in the way. I don't know how you intended to do it. Were you just going to put them on the screen and share it?
Would it be all right if we just let the record reflect that we're displaying the exhibits or demonstrative aids, Your Honor?
Absolutely. Yes, that's fine. What I would ask you to do is just make a reference to it. Like if it's exhibit 11, for example, you just say, exhibit 11 is now up, and then we'll go from there.
Thank you, Your Honor. With that, the defense is ready to proceed.
Okay. Mr. Spillner.
Yes, Your Honor.
Would you like to give
A
an opening
moment to
statement?
readjust my camera.
Absolutely.
Sunny Mehta wanted to play bar owner. She wanted the fun of owning a bar, but none of the responsibility. Sunny didn't take her responsibility seriously, and as a result, someone died. It's March 24th, 2019, the last day of spring break. Jessica Marks and her childhood best friend Morgan Levin are planning to go out for a fun evening by the coast at Sunny's rooftop bar in Malibu. Jessica knows that she wants the last night of spring break to be fun. But what Jessica doesn't know is that her last night of spring break was also the last night of her life. You will hear later that evening, Sunny Mehta served Jessica Marks alcohol. The evidence will show that as she got drunker and drunker, Sunny continued to serve Jessica, even after she was obviously intoxicated. Jessica then tried to drive herself home, but just 1,000 feet from the bar, she swerved off the road into a ravine and died. Jessica Marks was only 19 years old. Her life was just beginning. Today, the plaintiff has brought a cause of action against Sunny's rooftop bar for wrongful death and under the California Business and Professions Code. We have the burden of proof to prove three things. Jessica Marks was under 21 at the time of her death. Sunny's rooftop bar served Jessica after she was obviously intoxicated, and Sunny's actions were a substantial factor in Jessica's death. And you'll hear evidence establishing each of these things today. First of all, it's undisputed that Jessica was under 21 years old at the time of her death. She was 19. You'll also hear that Sunny's actions were a substantial factor. After all, Jessica crashed just 1,000 feet from the site, and her blood alcohol content at the scene was 0.16, twice the legal limit for adults, and 16 times the limit for a 19-year-old. And finally, you'll hear overwhelming evidence that Sunny's rooftop bar served Jessica Marks while she was obviously intoxicated. Sunny Mehta served Jessica's table at least 8 alcoholic drinks in less than 3 hours. The evidence will show that as the night progressed and Sunny kept serving her drinks, Jessica got drunker and drunker. Morgan Levin will testify today that Jessica's eyes were bloodshot. She smelled of alcohol. She was slurring her words and she was stumbling. You'll hear that Sunny Mehta even pointed at her and said, "I hope this one's not driving." Now, you'll also hear today that March 24th, 2019 wasn't the first time that Sunny Mehta served a minor alcohol. It had happened before in 2018, and Sunny Mehta clearly didn't learn her lesson because she served a minor alcohol again, only this time that minor ended up dead. Sunny Mehta wanted the fun of owning a bar, but none of the responsibility. Now, you'll hear that not only did Sunny's rooftop bar fail to stop serving Jessica after she was obviously intoxicated, not only did they fail in their basic responsibilities as a bar, but they let Jessica Marks die and need to be held accountable. And this is why at the end of today's trial, we will ask you to hold Sunny's rooftop bar liable. Thank you.
Thank you, Mr. Spillner. Ms. Hill, would you care to make an opening statement now, or do you want to reserve it?
We'll make ours now. Just a moment to readjust, please.
Absolutely. Take your time. Just get started whenever you're ready.
Your Honor, Mr. Spillner, ladies and gentlemen of the jury, may it please the court. Everything was fine until she chose to drive. Mr. Spillner just came up here and he had an awful lot to say about Sunny's rooftop bar. He told you that what happened to Miss Marks on March 24th, 2019 was a tragedy. We agree. He told you that Sunny's bar sold Miss Marks alcohol while she was a minor. We agree with that as well. But then Mr. Spillner said that Miss Marks died because Sunny Mehta just wanted to play bar owner. Now that is where we disagree. Because what if I told you that the plaintiff's star witness, Morgan Levin, is on record lying to police? What if I told you that the bar's owner, Sunny Mehta, interacted with Miss Marks over 8 times that night and never saw once where she was acting drunk? What if I told you that Miss Marks arrived at Miss Mehta's bar with a fake ID, already planning to drink and then drive? Would that change things for you members of the jury? Everything was fine until she chose to drive. Now today, it's the plaintiff that has accused Miss Mehta's bar of causing the death of Miss Marks. And now Judge Corey's going to instruct you that it is their job to prove, more likely than not, that the employees at this bar knew Miss Marks had too much to drink. They will fail to meet that burden because Judge Corey's going to instruct you that we've brought what's called an affirmative defense. Now, while I know it might be difficult, what we'll ask you to do is to take a look at Miss Marks's actions that evening. If we can prove that more likely than not, it was her decisions that caused her death, well, then you won't be able to find Sunny's bar liable. As we go through today's trial, I want you all to hold on to 3 questions. Plaintiff will be unable to answer, and as a result, will be unable to meet their burden. Question 1, can the plaintiff's witness, Morgan Levin, be trusted? I want you all to pay attention to the motivations behind Miss Levin testifying today. You see, you're going to learn that originally, the plaintiff threatened to sue Mr. Levin and not the bar for Miss Marks's death. You'll see that after that threat was made, his story changed. His story changed to the story that the plaintiff will tell you today. Question 2, what did the employees at Sunny's bar know? Now today, you're going to hear from Miss Sunny Mehta that she interacted with Miss Marks all night and never once saw those signs of obvious intoxication. You're probably asking yourself, if Miss Marks was never showing those signs of obvious intoxication, then why are we here today? Well, that brings me to my 3rd question. Who made the deadly decisions? Now today, we won't dispute that what happened to Miss Marks was terrible and heartbreaking. But we're going to ask you to take a look at Miss Marks's decision that night. You're going to hear that Mr. Levin had begged her to take an Uber home, but you'll learn that Miss Marks insisted she was fine and that she was the one who chose to drive. At the end of this trial, I'll ask that you find Sunny's rooftop bar not liable, because everything was fine until she chose to drive. Thank you.
Thank you, Ms. Hill. Mr. Spillner, are you ready to call your first witness?
Yes, Your Honor.
Okay, please proceed.
The plaintiff calls Morgan Levin. Good afternoon, Mr. Levin.
Good afternoon, sir.
Could you please introduce yourself to the court?
Hi, my name is Morgan Levin.
I want to talk about how you're involved in today's case. How do you know Jessica Marks?
Jess and I, we grew up together. We met in middle school. We actually had the same birthday.
Now, I understand that this might be difficult for you, but when was the last time that you saw Jessica?
2 years ago, March 24th, 2019.
How old was she?
19.
Now, were you with Jessica on March 24th?
I was.
Why was she with you?
Well, Jess had came over that week. We were celebrating spring break together.
Now, what bar did you go to that night?
Sonny's rooftop bar.
How'd you get there?
Jessica drove.
And what time did you arrive?
I think it was 9.
Now, when you arrived, what was Jessica looking like?
I mean, she didn't look great. She looked buzzed, tipsy. She looked like she was feeling ill, and she lost her balance walking into the bar.
Now, what did her eyes look like?
Bloodshot,
What did she smell like?
alcohol.
And how did she sound?
Her speech was slurred, and she was pretty loud as well.
Did you and Miss Marks order any drinks at Sonny's?
We did.
Who's your server?
Sunny Mehta. I think she's the owner of the bar, actually.
Now, I want to talk about the drinks that you had that night, one by one. Now, as we talk about them, my second chair, Mr. Ortega, will be displaying each of the drinks that Jessica had on the screen. Now, what did she order first?
Red wine.
Did Jessica have any White Claws?
Yeah, 3.
Now, did she have any beer?
Yeah, she had an IPA can.
Were there any shots?
Yeah, 2.
To your knowledge, do these drinks on the screen accurately depict what Jessica Marks had that night?
Yeah, it does. Yes, sir.
Now let's talk about what you observed in terms of how these drinks affected Jessica. Can you name some other symptoms that she showed while at the bar?
Sure. Like I said, she had bloodshot eyes. She looked like she was losing her balance. She slurred her speech. Looked like she had a loss of concentration. Things like that.
Did she make sense to you?
No, sir.
Did you take any videos of Jessica while you were at the bar?
I did.
Now, I want to show you what's been pre-marked as Exhibit 10. Do you recognize this?
I do.
What is it?
It's a video I took of Jess that night.
We offer Exhibit 10.
Pardon me, any objection, Ms. Hill?
Yes, Your Honor. Objection under 403, more prejudicial than probative.
Your Honor may be heard.
Sure.
Your Honor, this is relevant to the second element of the plaintiff's cause of action, obvious intoxication. Your Honor, I expect that this video will show that Jessica was intoxicated.
Okay. Ms. Hill, what's your response?
Your Honor, today the plaintiff has filed a suit against Sonny's Bar for wrongful death. When they filed the suit, they were very specific that they're accusing the bar of over-serving Miss Marks, knowing that she became obviously intoxicated and not cutting her off. This video we expect to show Miss Marks holding some drinks and talking. But we have it on a good faith basis that they'll be unable to show that the employees of this bar saw Miss Marks acting like this. So without testimony that the employees of this bar knew, it's going to prejudice the jury to believe that because Miss Marks acted a certain way in front of Mr. Levin, that Sonny's Bar must be liable. It's an
May be heard. Your Honor, may be heard.
Hey, hang on, Ms. Spillner. I am going to give you an opportunity because, go ahead.
Oh, yes, Your Honor. So as an offer of proof, I expect that Mr. Levin will testify that this video was taken at 11:11 p.m. At Sonny's rooftop bar. And because Sonny Mehta and his other employees at the bar were serving Jessica around this time, it means that there is a possibility that they did see Jessica Marks act like this.
Okay. So just to clarify, Mr. Spillner, So this video that you're going to show is actually taken at the defendant's business that night?
Yes, Your Honor, that's correct.
Okay. So Ms. Hill, do you have anything you want to respond to Mr. Spillner at this point?
Yes, Your Honor. Mr. Spillner's responses were just explaining the relevance of this video, which wasn't my objection. We understand and we agree that this video does have some probative value, but that probative value is substantially outweighed by its prejudicial value. Just because Ms. Marks was acting it up in front of a video for Mr. Levin doesn't mean that she was acting like that whole night, nor that employees at this bar saw her acting like this. It's inadmissible.
I don't think
Your
you're
Honor,
going to, Mr. Spillner, I'm going to just stop because I did let you guys go back and forth a few times. So I'm going to allow the video to be shown. I appreciate your objection, Ms. Hill. I think it is probative and the jury can assess and take it for what it's worth. I mean, perhaps, I haven't seen the video, perhaps she's singing a song or acting up or something, but that sounds like it goes to weight, not admissibility. I think the jury can distinguish between what factors are relevant and what are not relevant from the video. So with that ruling, I'm going to allow Mr. Spillner to display the video for the jury.
Yes, Your Honor. Mr. Ortega, could you play the video for us?
A model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Mr. Levin, what time did she post this video?
I want to say a little after 11.
How would you describe Jessica's behavior?
She looked drunk.
Now, I want to talk about what Sonny Meta saw. You stated earlier that Sonny was Jessica's server. Around how many times would you estimate that they interacted with one another?
I can't be for sure, maybe 11, 12 times.
Now, at one point, did you see Sonny interact with Jessica on the stairs?
Yes, sir, I did.
What happened?
So I think it was around 10. Jess and I were walking down the stairs. We were going to the bathroom, and Jess stumbled. She grabbed the railing, and she actually hit Sonny Menta, like I said, the owner of the bar.
What was Sonny's reaction?
He said, or she said something along the lines of, "Whoa, we might need to cut this one off."
And did she end up cutting Jessica off?
No, sir.
Now, what time did you leave the bar?
Around 11:50.
So after the stumble, how much longer did Jessica stay?
Maybe about an hour and a half.
Now, did Sonny say anything else about Jessica that night?
Yeah. So it was toward the end of the night. Sonny actually came to our table. She kind of nudged me a bit and pointed at Jessica, and she said, "This one's not driving home, right?"
Now, after that, did Sonny Meta continue to serve Jessica?
She did.
Now, I understand this must be difficult for you, but what happened to Jessica Marks later that night?
She died in a car crash.
How far did she make it?
Maybe 1,000 feet.
Thank you, Mr. Levin. I have no further questions.
All right, thank you, Mr. Spillner. Ms. Hill, would you like to cross-examine the witness?
Yes, Your Honor.
Please proceed.
Good afternoon, Mr. Levin. Can you see and hear me all right?
Yes, ma'am, I can.
I want to begin by saying that I'm sorry for your loss. If you need a moment, please let me know.
Thank you.
I want to start right where you left off on direct. You were with Miss Marks when you two left the bar.
Yeah, I was.
You walked outside to the parking lot with her.
Yes, ma'am.
You were with her when she got to her car.
I was.
You saw her keys in one hand.
I didn't see her keys, no, ma'am, but I saw her enter her car.
So you saw her going to open her car door.
Yes, ma'am.
And as you saw these things, you told Miss Marks to take an Uber, right?
I did. I pleaded to Jess that she ride in the Uber with me, but
Exactly. You begged her not to drive away, right?
I did.
But Miss Marks insisted that she was fine.
She did. She was.
Let's move on. I want to talk about what you can't remember in today's case. And now there are some things from March 24th that you can't remember, right?
Sure. Yeah, I mean, I can't remember the entire day. No, ma'am.
Well, you testified on direct examination, and I wrote it down just to be sure, that Jessica looked buzzed, tipsy, bloodshot, smelled like alcohol. Did I get those things right?
Yes, ma'am.
But you can't point to a specific time in the night when Jessica was talking loudly, can you?
When she was entering the bar, ma'am.
But you don't have an exact time for that?
I believe we entered the bar at 9 o'clock.
Well, Mr. Levin, you can't point to a specific time in the night when Miss Marks's eyes got red, can you?
Yes, ma'am, I can, when we were entering the bar.
Well, Mr. Levin, is that a specific time that you can point to?
Yes, ma'am. I think it was 9 o'clock.
Well, you didn't write down or note a specific time when one of Sunny's employees saw these symptoms, did you?
No, ma'am, I didn't. I didn't bring a journal or anything.
But there is something that you do remember from that evening.
I'm sorry, ma'am. What was the question?
There is something that you do remember that evening, right?
Sure. Yeah. I mean, I remember a lot. I don't remember the entire day. No, ma'am.
And one of those things you remember is that you remember how much Miss Marks had to drink.
Yeah. Yeah.
Now you testified on direct that she had 6 drinks. Did I hear that correctly?
Around 6. Yes, ma'am. That's true.
Well, sir, do you remember talking to a police officer that night?
Yeah, I think so. I think she worked with the LAPD.
You remember talking to her after Miss Marks's car crashed?
I do.
And you remember being shown in your deposition the report that was created by that officer, right?
I think so.
Is that a yes?
I think so, ma'am. I believe so. That's correct.
Ms. Perret, can we get that report on the screen? Let the record reflect that we're displaying Exhibit 23, which has already been admitted. Mr. Levin, I'm going to read from specific lines. Please follow along as I read out loud. Levin acknowledged that Marks had a few drinks and that Levin had a few also. When I asked what Levin meant by a few, Levin said, I don't know, 3. Did I read that right?
Yes, ma'am. I had 3 drinks that night.
Now, on March 24th, 2019, the story that you told the police officer was that Miss Marks only had 3 drinks, right?
No, ma'am. I said that I had 3 drinks.
Ms. Perret, can we pull that report back up on the screen? Well, you said here that when you were asked by what a few meant, you said 3, right?
Right. Yes, ma'am. In reference to when I said a few.
And when you said Miss Marks had a few drinks,
I meant 6, ma'am.
but you did say that she had a few drinks that evening.
Yes, ma'am, I did.
So in between, so that wasn't the 6 drinks that you told the jury today, was it?
I'm sorry, ma'am, I don't understand.
The 3 drinks that you told the police officer that night, that wasn't the 6 drinks that you told the members of the jury today, was it?
Ma'am, I had the 3 drinks.
Let's move on. Now you understand that today the plaintiff in today's case is Jessica's mom, right?
Yes, ma'am, Miss Ethel.
And when Jessica died, her mom threatened to sue you,
She did.
and you started talking to Miss Marks' attorneys.
I did.
They asked you to testify in today's case.
Yes, ma'am, they did. I happily obliged.
So yes or no, Mr. Levin, today you're testifying on behalf of someone who had previously threatened to sue you, all right?
I'm testifying for Jessica, ma'am.
Is that a yes?
I mean, I guess so, but I'm testifying for Jessica.
Thank you, Your Honor. Nothing further.
Thank you, Ms. Hill. Mr. Spillner, would you like to redirect?
No redirect, Your Honor.
Okay. Since there's no redirect, Ms. Hill, you're not going to get any recross. So do you have any further witnesses, Mr. Spillner?
No, Your Honor. At this time, the plaintiff rests.
Okay. Ms. Hill, whenever you're ready, do you want to proceed with the defense case?
Yes, Your Honor. The defense calls Sunny Mehta to the stand.
Okay.
May I proceed, Your Honor?
You may.
Good afternoon, Miss Mehta. Can you see and hear me all right?
Yep, you look perfect.
Could you introduce yourself to the ladies and gentlemen of the jury?
Of course. My name is Sunny Mehta.
Well, Miss Mehta, what do you do for a living?
Well, I like to think of myself as an entrepreneur, a businesswoman, if you will. I've owned a few businesses. I'm currently looking for a new one to plan, but I was the bar owner of Sunny's Rooftop Bar.
Miss Mehta, are you aware of the allegations the family of Jessica Marks is bringing today?
I am. It's tragic what happened.
How do you respond to those allegations?
They're blaming me for over-serving her, but I swear whenever I saw Miss Marks, she was fine.
Before we talk more about that night, I want the jury to know a little bit more about your business. How'd you get Sunny's Rooftop Bar started?
Got out of high school and I was working a few odd jobs just to make ends meet, make money, but I had a dream to be a bar owner, and my parents saw in me and they helped me buy my business.
Ma'am, when you opened up Sunny's Rooftop Bar, did you get a liquor license?
Of course, it's required by law from the state. And so I took the exam and I got my certification.
And with this exam, did you learn how to spot someone who might have had a little too much to drink?
Of course, that's part of the training. I have to know how to identify when someone is intoxicated and look for the signs.
Well, what are some of these signs?
There's really a bunch of them, but just to name some of the common ones: slurring your words, flushed face, bloodshot eyes, vomiting, stumbling around, loss of hand-eye coordination, especially when they're passed out.
Well, with that in mind, I'd like to move forward to the night of March 24th, 2019. You said earlier that Miss Marks was at your bar that night. What time did she come in?
Must have been around 9 p.m.
And before Miss Marks walked into your bar at 9 p.m., had you ever seen her before?
No, this was my first time seeing Jessica.
Was there anyone there with her?
There was. Her friend, the one that just came before me, Morgan Levin.
What time did Miss Marks and Mr. Levin leave?
11:45. We usually close at midnight, so they were one of the last ones to head out.
Well, I want to talk about what happened between 9 and 11:45. What happened when the two of them first arrived?
When they came in, they went to the rooftop like most our customers. I mean, it's prime real estate, really. We've got a nice view of the ocean.
Did you start serving them?
I did. I went up to the rooftop and I took their orders.
And at that point, when you first started serving them, did you see any of those signs that you mentioned earlier?
No, not at all. They both seemed totally fine. No signs.
How many times did you talk to them that night?
Over the course of the night, I took their orders, I served them, so probably around 8 to 10 times.
Well, during those 8 to 10 times you were at their table that night, did you ever see those signs you mentioned earlier in Miss Marks?
No, not at all. Never.
Now, how about at 11:45 when Miss Marks was leaving your bar?
When she left my bar, she seemed fine.
Why do you say that she seemed fine?
Well, as a bar owner, when I'm cleaning up on the bottom, I've got a staircase that goes up to the rooftop, and when people are coming down, I take a look at them, get a gauge of how they're doing after drinking, and when Jessica Marks walked down the stairs, she was fine.
Well, Miss Meta, you said that you saw Miss Marks go down the stairs fine. I want to give you a chance to respond to something the plaintiff brought up during their case. Were you here for the direct examination of Morgan Levin?
I was.
Did you hear Morgan Levin testify that Miss Marks was stumbling on the stairs?
I did. I don't know why he's saying that kind of thing. That never happened.
Miss Meta, on March 24th, 2019, did you have any reason to believe that Jessica Marks was obviously intoxicated?
No, none at all. Whenever I talked to Jessica, she was fine. She was holding conversations. She was laughing, having fun, nothing.
Did you have any reason to believe that she should have been cut off?
No, not at all. My training is to look for the signs, and I do. And when I looked for them that night, there was nothing from Jessica.
Thank you, Miss Meta. Nothing further, Your Honor.
Cross-examination, Your Honor.
Please proceed, Mr. Spillner.
Good afternoon, Miss Meta.
Good afternoon, sir.
Now, your parents bought you Sonny's rooftop bar in February of 2017.
Yeah, they did.
And ma'am, before owning Sonny's, you had no prior experience working at bars.
That's right. I didn't, but I wanted to be a bar owner.
I'm showing you what's been pre-admitted as Exhibit 1. This is your bar's plea agreement to a previous crime, correct?
It looks like it.
This is your signature.
That's my signature down there.
Now, Miss Meta, the year after you bought the bar, you pled guilty for serving alcohol to a minor.
Look, I did, but I didn't know that they were a minor.
Today's case wasn't the first time that a minor has been illegally served at your bar.
Yeah, you're right. But again, I didn't know they were minors.
Now, Miss Meta, as a part of the agreement, you agreed to have an ID scanner, correct?
I did. Yes, we had one at the bar.
If you had an ID scanner, you would have known for sure that everyone in your bar was legally drinking.
Of course, we used it all the time, but it always broke every now and then, so.
That's right, Miss Meta. A few weeks before March 24th, your ID broke. Your ID scanner broke.
That's right. It did.
And on March 24th, you still hadn't replaced the scanner.
That's right. Sometimes it just kind of went out, so we waited for it to stop working, but it hadn't worked in a while. We were planning on getting a new one.
Now I'm showing you Exhibit 23, which has also been pre-admitted. This is a police report. I believe Miss Hill talked about it earlier. Now, according to this police report, your bar had a reputation for serving underage college students.
That's what it said It probably was from the bar owner before me and the place that I leased, though. I heard something about that, but not my bar.
Now, I want to talk about the night of March 24th. Now, you served Jessica Marks's table 2 beers,
Yeah, I served her table.
3 White Claws,
I served the table that, yeah.
2 green tea shots,
They were on special on that Sunday. I served the table that.
and you also served her a bottle of wine. Is that correct?
For the table, sir.
And that's at least 8 alcoholic drinks that you served at Jessica Marks's table.
No, sir, I don't think you're hearing me. I served that to the table.
Yes, that was my question, Miss Meta. You served 8 alcoholic drinks to the table.
That's right, to the table with Miss Marks and Levin, who just came up here.
And now, when you first saw Miss Marks, you thought she was around 5 feet tall.
I don't like to guess people, but she was kind of short.
That's right. It's fair to say you thought she was small.
Short, yeah.
Now, I'm showing you Exhibit 10, which has already been admitted. This is a video of Jessica at your bar the night of March 24th. And now, before your deposition, you hadn't seen this video,
That's right. I'd never seen it before then.
and you said in your deposition that if you saw Jessica acting like this, you would have been concerned.
I would have been concerned enough to look after her while I was serving, but I never saw her like this.
You would have been concerned, correct?
Yeah, probably would have kept an eye on her, but she was never like this when I was around.
Now, Miss Meta, you're aware this video was posted at 11:11 p.m.
If that's what you're telling me, then yeah.
Jessica arrived at your bar at 9, right?
That's when I saw her walk in.
So when this video was posted, Jessica had been in your bar for at least 2 hours and 11 minutes.
If I'll take your word for it.
Now, you were her server that entire time, correct?
I did. I served her on the rooftop. I don't know if she came downstairs at all.
And it's right that you enjoy interacting with your customers.
Of course, I enjoy owning my bar and talking to people. It's one of the things that I like.
And now it's right that Jessica Marks left your bar at 11:45.
Yeah, sometime before closing.
So after this video was posted at 11:11, she was at your bar for another 34 minutes.
I guess, yeah.
And you testified on direct that when Jessica Marks arrived, she looked perfectly sober, right?
She did look perfectly sober.
Then she spent almost 3 hours at your bar.
She did.
And after those almost 3 hours, she drove off.
I guess so, yeah.
And she wound up dead in a ravine.
That's what I've heard. It's terrible that that happened.
And now, when they took Jessica's blood alcohol content, you're aware it was 0.16.
Yeah, I didn't know that before.
And 0.16 is twice the legal limit, correct?
Yep, the legal limit's 0.08. We were supposed to learn that in training.
Thank you, Miss Meta. I have no further questions.
Ms. Hill, did you have any redirect?
Yes, Your Honor, just a brief redirect.
Please proceed.
Ms. Meta, on cross-examination, you were asked about why you didn't scan the IDs that evening with an ID scanner. Why was that?
Well, just like I said, our ID scanner was broken. I mean, it broke every now and then, but it broke pretty long this time.
You were also asked about whether you had served alcohol to minors in the past. Now, on March 24th, 2019, did you know that Miss Marks was a minor?
Objection,
No,
Your
of
Honor.
course not.
Relevance. May be heard.
Yes, go ahead.
Your Honor, according to jury instruction 11, it's irrelevant whether or not Sunny Meta knew Jessica Marks was under 21 years of age, regardless of what Sunny Meta knew. As long as Jessica Marks was under 21 years of age, the plaintiff's cause of action has been met. Therefore, it's irrelevant whether Sunny Meta knew she was under 21 or not.
Ms. Hill.
Your Honor, today the plaintiff came here with the burden that they had to prove that Sunny's bar sold alcohol to a minor and that they saw her become obviously intoxicated and that they didn't act on it. Now, in today's case, whether or not Miss Meta knew Miss Marks was a minor is extremely relevant. And not only that, but on cross-examination, Mr. Spillner actually attacked her for serving alcohol to minors in the past. So it's perfectly within Miss Meta's rights to clarify whether she knew Miss Marks was a minor.
Your Honor, maybe her.
Hang on, I don't want to leave Ms. Hildy just yet. I understand the latter point. The latter point's pretty persuasive to me, but you also said that it's relevant whether she knew she was a minor or not. What's it relevant to, Ms. Hill?
Well, Your Honor, that in itself isn't, it is already stipulated to today that Miss Marks was a minor. And it isn't one of the elements that's needed to prove, but seeing as Mr. Spillner did attack her for serving minors in the past, it's definitely within Miss Meta's rights to clarify whether or not that was intentional and whether or not she knew Miss Marks was a minor on March 24th.
Okay, I get that. Okay, all right. Mr. Spillner, what's your position?
Yes, Your Honor. Your Honor, that doesn't change the fact that whether Miss Meta knew or didn't know that Jessica Marks was a minor, that doesn't change the fact that it's still irrelevant to today's elements. Your Honor, there are only two different burdens of proof in this case. One, that Jessica Marks was obvious, where the plaintiff's cause of action that says Jessica Marks was obviously intoxicated, that Sunny's serving was a substantial factor, and that she was under 21, regardless of whether Sunny Meta knew that or not. Your Honor, it doesn't matter whether Sunny Meta knew Jessica Marks was underage. Ms. Hill's argument still does not address that part of it.
But Mr. Spillner, weren't you the one that attacked this witness, suggesting that she may be open to selling alcohol to underage people? Didn't you do that on your cross-examination?
Yes, I did, Your Honor, but that doesn't change the fact that it is irrelevant whether Miss Meta knew or didn't know that they were underage. By using that point on my cross-examination, all I was trying to do was say that she had a reputation for serving underage minors.
But my point is, you've attacked her credibility, her business practices by raising that point. Don't you think that it would only be fair to the defense to allow them to rebut it, to talk about, and I don't know if this is the case, what she does to verify that people are of age, what she does to, when she discovers somebody that's underage, how she handles it? Seems to me that she's allowed to try and rehabilitate that issue, especially since you've opened up that issue in your attack. Does that, you understand what I'm thinking?
Yes, Your Honor, I understand what you're thinking, but I still think this part is irrelevant just because it does not relate to the elements.
Fair enough. Reasonable minds may disagree. I'm going to allow this line of questioning to continue, though, and overrule your objection.
Yes, Your Honor.
Did you get a chance to answer my question, Miss Meta?
No, I didn't. Could you repeat the question, please?
On March 24th, 2019, were you aware that Miss Marks was a minor?
No, of course not. I wouldn't serve a minor if I knew that they were a minor.
And on March 24th, 2019, did you see any of the signs of intoxication that you mentioned earlier in Miss Marks?
No, of course not. I told you the signs. I did the training to look for them. And when I saw Jessica Marks, I never saw any.
Thank you. Nothing further, Your Honor. May this witness step down?
Does Mr. Spillner get an opportunity to recross?
Yes, Your Honor, but I do not want to recross.
Okay, well, he gets the opportunity. He's declining. So yes, the witness may step down. Thank you, Ms. Mehta. With that being the case, while Mr. Spillner gets ready to give his closing argument, could I just have like 5 seconds while I finish a note that I'm working on?
Yes, Your Honor.
Of course.
Mr. Spillner, thank you for taking or giving me the opportunity to get caught up. I'm ready when you are.
Yes, Your Honor. May it please the court. Sonny Mehta wanted the fun in owning a bar, but none of the responsibility. Sonny Mehta wanted to play bar owner, but not act as one. Now, Miss Mehta's actions, or lack thereof, had consequences. Consequences that a 19-year-old college student didn't deserve. Now, we're asserting one legal claim in this case, a wrongful death under the California Business and Professions Codes, section 25602.1. Let's look at the elements of this claim. First of all, it's stipulated that Jessica's birthday was January 20th, 2000, which means that she was 19 years old at the time of her death. And it's obvious that Sonny's overserving was a substantial factor. Today you heard that Jessica Marks stayed at Sonny's rooftop bar for almost 3 hours, where she was served alcohol continuously. You then heard that she only made it 1,000 feet from the bar when she swerved off the road into a ravine and died. And when the police took her blood at the scene, Jessica had a blood alcohol content of 0.16. For context, that's twice the legal limit for adults and 16 times the limit for a 19-year-old. This means that what this case comes down to is whether Jessica Marks was obviously intoxicated when she was served at Sonny's rooftop bar. And there was overwhelming evidence that she was. Jessica Marks was a small person, only 5 feet tall and 115 pounds, which means that alcohol affected her more quickly. And add this to the fact that Jessica and Morgan's table was served 8 or more alcoholic drinks in less than 3 hours, it makes sense that Jessica exhibited the signs of obvious intoxication. Now, the court will give you guidance in the jury instructions on how to identify these signs. Now, let's take a look at them. Now, Morgan Levin testified today that Jessica smelled of alcohol, slurred her speech, didn't make sense, had bloodshot, watery eyes, was loud, and was wobbly. He also testified that Jessica exhibited 2 more symptoms, poor muscular coordination and a loss of balance when she stumbled down some stairs at around 10 p.m. Now, it's obvious to you, and it was obvious to Sonny Mehta, that Jessica Marks was obviously intoxicated. Sonny Mehta saw Jessica Marks when she arrived at the bar. He was her server that night for almost 3 hours. She went to her table 8 to 10 times, and we also know that she interacted with Jessica all throughout the night, something that she admitted she enjoyed doing. Now, Sonny's own words corroborate this. She knew how drunk Jessica was. Now, Mr. Levin told you on direct examination that when Jessica lost her balance on the stairs, she stumbled right into none other than Sonny Mehta. Now, not only did Sonny witness this Jessica stumbling, but her own words acknowledged that she knew how drunk Jessica was. And now when she stumbled into her on the stairs, Sonny admitted that Jessica was looking drunk, saying, "We might need to cut this one off." Now, ladies and gentlemen, cutting Jessica off would be the responsible thing to do. But as we've learned in today's case, Sonny Mehta is not a responsible person. So did she cut Jessica off when she was obviously intoxicated? No. Jessica Marks was at Sonny's rooftop bar for another hour and 45 minutes. Now, not only did she acknowledge that she might need to cut Jessica off, but Morgan Levin also testified today that at one point, Sonny Mehta pointed to Jessica and said, "I hope this one's not driving." Now, Morgan also testified that after saying this, Sonny Mehta served Jessica Marks another round of alcohol. As I said at the beginning of this trial, Sonny Mehta was playing bar owner. She wanted the fun in owning a bar, but none of the responsibility. Jessica Marks shouldn't even got to the point of being obviously drunk if Sonny's rooftop bar had taken minimal measures to ensure the safety of her customers. Now, you heard today that Sunny's Rooftop Bar was required to have an ID scanner to prevent underage drinking, but on the night of March 24th, failed to have one. And now, if they had that ID scanner, Jessica Marks wouldn't have been served alcohol in the first place. Now, serving minors was also nothing new to Sunny Meta. You heard her bar had a reputation for serving underage college students. Also, a year prior to March 24th, she admitted to her bar pleading guilty to illegally serving minor alcohol. On March 24th, 2019, Sunny's Rooftop Bar served a minor alcohol yet again. Only this time, that minor died. Now, despite Jessica being obviously intoxicated, you heard today that Sunny's Rooftop Bar ignored their responsibilities and did nothing. And they didn't care for Jessica's safety. They didn't cut her off. They let Jessica Marks drive, and they let her die. Sunny Meta wanted to play bar owner. She wanted all the fun, but none of the responsibility. And when someone doesn't take the responsibility seriously, and as a result, someone dies, there needs to be accountability. It's up to you to hold Sunny's Rooftop Bar accountable. Thank you.
Thank you, Mr. Spillner. Ms. Hill, take a minute if you need a minute to get yourself organized, and then just get started whenever you're ready.
May I proceed, Your Honor?
Please.
I don't remember. 3 words. The 3 words that most perfectly sum up the plaintiff's case today. You see, today, Mr. Spillner had one job. He had one job to answer one question. What did the employees at Sunny's Bar know? It's the question that you all as the jury will have on your mind when you go to deliberate soon. It's the question that the law requires the plaintiff to answer. But the problem is that as I stand before you today, despite having 2 years, 3 months, and 30 days to answer this question, the plaintiff still hasn't been able to answer. They had the chance to do so when they called up their only witness to the stand. Now, Mr. Spillner showed you this extensive list of symptoms of all these signs of obvious intoxication that Ms. Marks was apparently showing, but never once did he ask her about a specific time when these signs were being shown in front of my client's employees. So when I got up and I cross-examined him, I asked him that same question. And an answer that most perfectly sums up the plaintiff's entire case was, I don't remember. As this trial comes to a close, the evidence is clear. Everything was fine until she chose to drive. Today, it was the plaintiff that accused Miss Meta's bar of causing the death of Miss Marks. And now that's a serious accusation, and with that accusation comes a burden. Judge Corey is going to instruct you that their burden was to prove that it is more likely than not true that the employees at this bar knew Miss Marks had become intoxicated and that they should have cut her off. Today, we're not disputing that a bar like Sunny's has a legal responsibility to protect their guests. And we're not disputing that what happened to Miss Marks was terrible and heartbreaking. But what we are disputing, and what the plaintiff has failed to prove, is that Miss Meta was just playing bartender. But that's not the only reason Miss Meta's bar can't be found liable. As I mentioned in my opening, Judge Corey will instruct you that we've brought what's called an affirmative defense. Now, what we've asked you to do is to take a look at Miss Marks' actions on the night of March 24th. We had to show you that it's more likely than not true that her decisions caused her death. And if you find that to be more likely than not true, well, then you must find Sunny's rooftop bar not liable. Now, during my opening statement, I asked you all to hold on to 3 questions that the plaintiff hasn't been able to answer. Let's walk through those questions one by one and show you how the plaintiff has failed to meet their burden. First, let's start with the obvious. Morgan Levin can't be trusted. Today, the plaintiff's biggest witness became their biggest problem. You heard Mr. Levin admit that they're testifying on behalf of someone who threatened to sue them. In fact, there's something the plaintiff doesn't want you to see, something Mr. Spillner wants to hide from you members of the jury. Ms. Perret, can we throw that police report on there? You saw this police report where Mr. Levin said that both he and Miss Marks only had 3 drinks that night. But once he got on the stand today, he changed his story. Once he knew he'd be sued by the plaintiff's, by Jessica Marks's mom, his story changed so that the person the plaintiff's finger pointed at could change as well. And speaking of those drinks, let's talk about them. Because the second question that you don't have answers to, that Mr. Spillner was required by law to answer. What did the employees at Sunny's rooftop bar know? The problem is here that Mr. Spillner has tried to mislead you members of the jury. He told you that because one exhibit, Exhibit 10, shows Miss Marks doing a dramatic reenactment of a speech, that Miss Mehta's bar can be found liable. But what they chose to ignore are basic facts. Because while the plaintiff relied heavily on this video to prove that the bar's employees knew, their own witness admitted that he can't point to one specific moment where Miss Marks was showing these signs in front of the bar's employees. Miss Mehta told you under oath that she was looking for those signs from the moment Miss Marks walked into the bar until the moment she walked out. But they just weren't there. They didn't know. But there was one person who did, Jessica Marks. Because the answer to that third question is an answer plaintiff's counsel doesn't want you to make. Who made the deadly decisions? The only person in that bar who knew how much she drank was Miss Marks. She knew how she felt, she knew how drunk she was, and she knew that she would be making a deadly decision once she left that bar. She even acknowledged it herself. As her best friend was begging her to take an Uber, she insisted that she could drive regardless of what she drank. Up until the moment she got into her car, everything was fine. She wasn't stumbling, she wasn't even spilling her drinks. But when she got outside, chose to drive, chose to make that deadly decision, the worst possible thing imaginable happened. And I understand that it's difficult for you to find Miss Marks responsible for her own death, but it's what happened. And while the plaintiff wants to send you members of the jury off to deliberate with nothing but I don't remember one thing. Everything was fine until she chose to drive. Find the defendant not liable. Thank you.
Thank you, Ms. Hill. Mr. Spillner, did you want to offer a rebuttal?
Yes, Your Honor.
Go ahead.
And may it please the court. Ms. Hill stated on her closing that we rely solely on the testimony of Morgan Levin to prove our case. Well, ladies and gentlemen, that simply is not true. We have undisputed physical evidence that Jessica Marks's blood alcohol content was 0.16, 16 times the legal limit. And we have an undisputed video of Miss Marks, which corroborates Miss Levin's testimony. His testimony that Jessica Marks was showing signs of obvious intoxication. Sunny Mehta wanted the fun in owning a bar, but none of the responsibility. Therefore, we will ask you to find Sunny's rooftop bar liable. Thank you.
Ms. Hill, do you get a rebuttal?
Not in this jurisdiction, Your Honor. So I believe that concludes today's trial.
I love to give you the opportunity, but we're going to follow the law. So thank you. We are going to put our scorecards in, and then after we're done with that, then we will give comments. So great presentation, both sides. Thank you.